healthy during this crazy and tough situations around the world, and especially for those who fasting right now. In Indonesia, we are starting to fasting this week, and yeah, I hope we're all safe and healthy now. And first thing first, I want to introduce myself. Uh, my name is Lintang. I am a researcher in ELSAM, Institute for Policy Research and Advocacy, and I'm very honored to become a moderator for these interesting discussions. And as we know that today's discussions is the second live panel, uh, which is part of Goethe-Institut Indonesia program and called Digital Discourses, Privacy in the Age of Data Capitalism. And today's discussion is more about data privacy concept and regulation, which we will focus on various aspects of regulating commercial and governmental use of the data. And also in this context, we're not forgetting to discuss famous European General Data Protection Regulations, or GDPR, which often seen as a benchmark with several nations drawing inspiration from it. And it's following the questions, but how we have learned so far about how these new rules hold up in the practice, and what is actually Southeast Asia stance in this debate, and in the global flow of user data. Does it really matter where data is physically stored? And are there any alternative models to data ownership and access? And uh, for those interesting questions, to answer the questions, we have a very incredible speakers here joining us today. And let me introduce the speakers, our speakers today. First, we have my colleague here from Bangkok, Sutawan or Ploy. Hi, Ploy. She's a...
Hi, everybody.
Hi, how are you? So she's a founder of Bangkok-based human rights organization called Digital Reach, which explores the impact of technology on human rights in Southeast Asia. She previously worked for Forum Asia and Global Freedom of Expression project at Columbia University. She is a human rights researcher, analyst, and more recently, a privacy advocate. And her expertise is how technology affects freedom of expression and information, as well as a civic space. She also interests in the development of technology in Southeast Asia, including policies and practices of government and big tech, the effect of emerging technologies, and internet governance. So thank you, Chloe, to joining us today.
Thank you.
The second, we have Pak Tony Seno Hartono. He is currently an ICT professional who has been in the industry for 30 years. He is now freelancing as a CTO in an association, as well as an expert staff member at ministry level, a university researcher, and a book author. As a CTO at Microsoft, Tony led the technology and policy program with emphasis on cloud security and privacy. And prior to this, he was the director of advanced technology at Cisco System and a computer engineer at IBM Indonesia. Tony hopes to transform Indonesia people and organization into being more competitive through technology. Halo Pak Tony, apa kabar? Selamat siang.
Hello, Bu Lintang. I'm fine, thanks. How about you? Hello, everybody.
Yeah, I'm great. Yeah, thank you. Thank you for joining us today. And third, we have my colleague here from ELSAM, Mas Wahyudi Djafar, Director of Advanced Mas Wahyudi is a researcher and Deputy Director of Research at IBM Indonesia, the Institute for Policy Research and Advocacy, ELSAM Human Rights Organization in Indonesia, based in Jakarta. He focuses on topics such as the right to privacy, freedom and security sector reform. Wahyudi also handled many cases of judicial review in the Constitutional Court on issues research related to human rights in Indonesia. He is active in various forums that discuss internet and human rights issues, including Internet Governance Forum and the Global Conference on Cyberspace. And his research publications, policy paper, and writings can be found in a number of scientific journals, in the mass media, and on his personal website at Wahyudi Djafar. Halo Mas Wahyudi,
Halo
sehat?
Lintang, ya. How are you? Thank you.
Yeah, yeah, okay, good. Yeah. Last but not least, we have Ingo Dachwiz. I'm afraid, let me know if I'm pronounce your name correctly. So
Just
he is an editor at Netspolitik. Okay. So he is an editor at netspolitik.org. He is a communication scientist who writes, speaks, and podcasts about data politics, monitoring capitalism, and digital structure. He is a member of the Digital Society Association and is in the Social Ethical Chamber of the Protestant Church of Germany. At the beginning of 2020, he was an expert witness at the hearing of the federal government on its planned data strategy for Germany. So thank you, Ingo, for joining us today.
Thanks for inviting me.
So I guess I have introduced all the speakers here, and before we started, I want to explain our probably a small rundown our discussion today. So first, I'll ask some questions to warm up the discussion for the speakers based on the videos that have been uploaded on Goethe-Institut YouTube account, official account, and in the second session, I'll take some questions from the participants through Slido. And regarding to the question and answer session, all the participants here who join us through live streaming on YouTube can drop the questions through Slido. So you can open Slido, sl.do, on your browser, and then enter the code #Digital Discourses, and then you can drop your questions there, and with or without your name, so you can still be anonymous in Slido to ask the questions. And you can also just like the questions that have been asked from others if you think or you consider the question would be perfect questions to discuss this afternoon. So I guess that's the information. So don't forget to participate the question and answer sessions in Slido, #Digital Discourses. So, okay, I think we can start our discussion today. So to warm up the discussion, I'll ask some very broad questions. Like first, probably I'll go to Chloe to explain more about the concept of privacy as our title of discussion. So in the most of Asia country, in the most of Asian countries, there's a point of view that saying privacy is not part of Asia culture. So how do you see this notion how do you see this notion about the privacy is not part of the Asia culture? So Chloe, I give the floor to you.
Well, thank you, Lintang. I'm not really sure what is defined as the Asian culture, actually. I think that I can put it this way in terms of even in the most democratic country, privacy is important. It's actually the most basic value that people need. No matter which society you're living in, you need privacy in your daily life, in the way that you live. At some point, you would need to have, some privacy, whether you want to go somewhere, you want to do something, there would be some certain part that you might want to keep it private and don't want to share with others. That would be the answer.
Thank you, Ploy. Probably I'll ask Mas Wahyudi, what do you think about that notions? Because I think it's quite relevant when we're talking about the privacy in Indonesia. Also, you mentioned on your video about the criminal code in Indonesia actually have like a concern on privacy and also Japanese culture about the privacy. Could you explain more about that?
Yeah, thank you, Lintang, and hello, everyone. Yeah, for this question, I think it is the debate in Indonesia because most of the Indonesian sides and believe the privacy as a Western concept. So it is the Dutch colonial government bring the privacy concepts to Indonesia, and currently the Western people also endorse the Asian people, the Indonesian people, to adopt of the data protection system, reverse to private life, reverse to European Convention on Human Rights. But if we read several articles from many scholars on the privacy, while they are elaborate about the privacy concept in the pre-modern era, they mention about the Indonesians culture. They mention about the Japanese culture and Balinese culture, how the Balinese peoples and Japanese peoples conceptualizing of the privacy and in the pre-modern situation or the traditional era. But I have the hypothetic about the why the Indonesian people currently say the privacy as a Western concept, because the value, the concept of the privacy in the traditional era, in the pre-modern era in Indonesia, it is different with the privacy concept bring by the Dutch colonial governments. They are formulate of the privacy concept in the civil code, in the criminal code, and it is different with the concept in Indonesia. And currently, the Indonesian peoples filed to materialization or to materialize of the privacy concept based on the culture, based on the tradition, based on the Indonesian concept. So currently, we have the big challenging to how to formulation between the traditional concept or the value concept from Indonesia with the legal concept from Western Europe or legal concept from the US model about the privacy to develop of the new regulation on the privacy. Yeah, it is. I think the debate in Indonesia.
Thank you for the comprehensive and historical stories about the privacy in Indonesia. Pak Tony, would you add some like a challenge, especially for the challenge in industry about the privacy in Indonesia? Is there any like those kind of perspective in the, for example, in the industry?
Yeah, first of all, I would like to add some comment about the Pak Wahyudi opinion about privacy, and that's correct. Indonesian people, maybe I don't know in other Asian country, we don't really understand what privacy is, and this becoming problem in the industry. So, for example, in Indonesia, just for your information, if you are not Indonesian, usually if we visit one city or one village in Indonesia, you will be greeted by the villager or by the other people on that city. For example, what's your name? Where are you coming from? Where do you work, etc. So all of those are the question of privacy, and this happened on the young and older generation of Indonesia. But what I see is the younger generation of Indonesia is more having more understand of the privacy and becoming more careful. For example, I have small daughters, and they already know that to create a user ID in Roblox, they don't use the real name. She just invented a new name that cannot relate it to her. So this is something that I see is different. While the older people, something maybe my mother-in-law or maybe my mother or my my older relative, they don't really understand why other people like to send hoax and something like that. People has to be to tell the truth and something. So it means that the privacy is very different concept for them, and this becoming issue in the industry since now we are moving into the industrial revolution 4.0, and everything we leverage cloud services, and in the cloud every resources are shared, and also cloud computing enable the social media, so everybody can share information to other people, and this is where the privacy becoming issue. If you don't understand privacy, you can post everything about yourself on the social media, and this can be a security issue too. So for example, I have a friend who is working in the IT industry for I don't know 20 years or so, but it looks like when privacy is not embedded in herself. So when her mother gave her a credit card, she was very happy and then photo the credit card and put in the social media. We saw this and then remind her, hey, be careful with your credit card. So suddenly he realized that this is not right. So he take out the credit card photo. So even though somebody has a lot of experience, since intrinsically we don't realize what privacy is, sometimes we post something that can be dangerous for us. So that is why Indonesian government also try to make a law about the privacy, the private data protection law, but still in draft. We try to copy maybe 90% of the GDPR, but the first problem may be to educate people what is the meaning of privacy. So once they understand the meaning of privacy, we can, I believe, we can move forward one by one step by one step, yeah, toward a better understanding of privacy and better world of IT in Indonesia.
Yeah. So thank you, Pak Tony. I'll go back about the data sovereignty and cloud computing related to the privacy later. And now go to Ingo. You heard about the challenge, historical, and also the perspective in our Asian countries. So in your video, you mentioned that GDPR exists before the GDPR. You in European country have so many data protections law, and is it true that GDPR was pushed by civils with the European citizen because they have a concern or big awareness about the privacy things in European country?
Yeah, thanks for the question. Just before I answer this, I just want to point out that as there might be like different Asian approaches, as Ploy pointed out, to privacy, it's also many different understandings of privacy in Western discourses, for example. So also we have a different understanding in the US, for example, or slightly different, at least, understanding of privacy as we have in European countries, and also the privacy cultures between Germany, for example, and Northern European countries are very different. Yeah, just to point that out. But still, it is true for the European Union. We had this the Data Protection Directive from 1995, which was establishing some form of data protection regime. It's also not the it wasn't the first law. For example, in Germany, we had the first data protection law in the late 70s. But still the situation, although there was this directive for the whole EU, the situation across Europe was very different. So on paper, there was privacy law or there was data protection law protecting people's privacy or data, personal data. People tend to point out that data protection and privacy is not actually the same, but correlate, but it's not the same. And I mean, how GDPR evolved was quite an interesting story. I wouldn't say it was an initiative from the European citizens. I mean, because there's tools for citizens to at least some slight tools to push legislation for certain or to propose certain laws. This was not the case, but still there was a huge debate in the whole EU since the 2000s about the situation that data with what we call digitalization, so the widespread use and the importance of digital services and products for our daily lives, people had the feeling there was no control, and that this was mainly due to the fact that although there was law on paper, the authorities, data protection authorities, didn't have many powers to enforce it. So the initiative was from the European Commission and also some politicians from the European Parliament together. And actually it was, I wouldn't say the debate about it wasn't that, but it was quite stuck in 2012, 2013. And then what happened was the Snowden leaks. So this was a huge, or this was described as a huge turning point in the debate about European data protection regulation, because although, because this was this led to a huge public outcry in the European publics. And this was kind of a very important push to get this law done, to get behind those very huge lobbying battles and debates. So I'd say, that was one important issue.
Yeah, thank you for pointing out, Ingo. And as you mentioned about the various concepts about the privacy, we often hear about the two poles or two regime of the data protections, which is from European countries and I will say the American US data protections or privacy approach. So could you mention about the difference between the European and US approach on data protections?
Yeah, I'd say in the US approach is very much like focusing on the individual. So it was described as privacy as the right to be left alone. So it was like a very much individual right, not to be bothered by governments or by others, for example. While, as I'd say, in the European tradition, at least in German data protection laws since the 70s, and also in the European EU directive from 1995, privacy is also, or data protection is also understood as like a social concept that is not only about an individual's possibility to manage information and to have what the German constitutional court called informational self-determination, but also as data protection as a means to kind of cope with the power imbalances that and asymmetries that come with different that come with data. So that's a huge power imbalance between me as an individual, which is giving data to a data to a company, for example, to a data processor that does analysis with this data, that kind of analyzes me on the basis of this data, that has the means to compare me to others, for example. So data protection very much is understood, or should be understood, as a tool to cope with those power imbalances that come with personal data flows, and as a means to kind of socially, society-wise control the use of technology and also the development of technology. Yeah, that's what I say is the difference.
Yeah, thank you, Ingo, for the explanations. But as if I'm not mistaken, like about 2 years or I guess 2 years or last year, the California, where the most of the big tech company was located, now they have like California Privacy Act, which is, I guess it means that there are urgency to establish some of the data protection regulation there. So we're back to the Asian context, and because in the videos, Floyd explained about the Asian data protection regulations landscape, and for Ploy, how are the regulations and approaches different within Southeast Asia countries?
Can you repeat the question again? Sorry, the connection is not that good.
So yeah, okay. So how are the regulations and approaches differ within the Southeast Asia country?
I think that in terms of the difference, I'm not really sure whether there are many differences in terms of that, but they do share like the common character that I already explained in the presentation, that all of them except the Philippines, I mean those who already have the regulation in place, Malaysia, Singapore, Thailand, they seem to, well, they don't include the government as part of the data protection regulation. So in this case, it's created a lot of gap in terms of how the government can use or misuse or exploit the data in terms of using it as a surveillance tool against activists, government critics, something like that. And I think that for the upcoming technology that many of the Southeast Asia are planning to go forward, which is to create the smart city project using technology like 5G, implement the digital ID, for example, and also the use of the Internet of Things, the IoT, which is going to involve with a lot of data, and also the cross-border data flow as well. So in this case, it's really a challenge on how the data are treated in each country and also at the regional level, because when you have a different regulation, that the interpretation of what personal data is, and when the data is connected, so it's really challenging on how you treat the data in this case. So that's my concern. And also because of the weak regulation, there are I mean, in terms of those who don't have the data regulation in place, it made the situation in that country more more vulnerable compared to other country as well, because that means there's no regulation, no one that prescribe on how the data of the citizen in each country, in those countries that don't have any data regulation, should be treated. And that also creates the exploitation, make them more vulnerable in terms of their data being exploited and misused.
Thank you, Chloe. It's a very big challenge to in Asian countries. That, and you also mentioned in your video they're non for now, like they're non Southeast Asia's countries data protections regulations as robust as a GDPR, especially include the government as a data control, and it's still challenging to control the data controller and the data processor when it's public public institution or from the state institution. And I want to go to Mas Wahyudi. You could you add some more about it, and also probably can share a little bit about which model is Indonesia trying to go, and how far along is the process now?
Yeah, basically, the ASEAN countries follow the three models of the data protection law. The first follow the models of the EU GDPR, and the second follow the IPEC privacy framework, and the third follow the model OECD guideline on data protection. So, if we refer to the Singaporean data protection law on 2012, and the Malaysian Data Protection Act 2010, and Philippine Data Protection Act 2012, and the last Thailand Data Protection Law 2019. And in 2017, law also passed of the Electronic Data Protection Act in the Laos system. So basically, the models of the Singapore, Malaysia, and the Philippines, they follow the European Data Protection Direction on 1995, number 46. So currently, the Singapore, Malaysia, and Philippines have the initiative to amendment their data protection law to balancing with the European data protection models, and Thailand, the last data protection act in ASEAN, mostly they follow the EU General Data Protection Regulation. But the issue about the data controller or data protection authority or independent supervisory authority, it is the big challenging in ASEAN country, because the government try to control of the data and controls of the system, use of the government system. For example, in Malaysia, the data protection law just enforced to the private sector, but not enforced to the government sector. So the public sector are enforced by the Data Protection Act. So the member of the Data Protection Authority in Malaysia, they are from the Ministry of ICT and the several people from the government. In Singapore, the Data Protection Commission started as an independent commission, but the Secretariat of the Data Protection Commission, they are under the MDA, Media Development Authority, as a part of the Ministry of ICT. Even in Philippines, the Data Protection Commission, they are part of the Ministry of ICT. Even the law started of the Data Protection Commission as an independent commission, but the member of the commission elected by the president, by Duterte. Even in Thailand, the Data Protection Commission, they are elected by several of the ministry, including the Ministry of ICT and also, Ministry of Digital Society. Probably can refresh if the wrong, and also
Digital economy.
Yeah, digital economy and society, and the others also they represent from the national human rights institution. But currently we have the problem with the independence of national human rights institution in Thailand also, and in Indonesia in the bills, the current bill, there is no the formulation about the independent supervisory authority, because in the bills the authority to implement, to monitor, to oversight of the implementation of the data protection law set up by the government, by the ministry. But in the debate between the public, between the house member, between the government, we found the urgency of the independent supervisory authority, or in the EU GDPR called as a data protection authority. So we hope in the process of the deliberation in the House, we can endorse of independent supervisory authority, because in Indonesia, the data protection law enforced to the public sector and also to the private sector. So the public sector, the several ministry also compiling the data from the public. For example, in Indonesia, we have the debate about the administrative population, about the citizens' data, because the Ministry of Home Affairs compiling and the processing of the data from the peoples. And also the others ministry, for example, the Ministry of Health also conducting of the health surveillance to compiling of the health data from the peoples. And the others, the Ministry of ICT, for example, they also compiling the data from the policy of the SIM card registration in Indonesia. So the ministry can access of all of the data from the peoples and can processing of the data with the several purposes. So I think it will be better if the Indonesian data protection law in the future also have the independent supervisory authority to oversight the implementation of the data protection law.
Thank you, Mas Wahyudi. Maybe we can explore more about it, about the Data Protection Authority later. And I go to Pak Tony first. So the discussion regarding the privacy, especially in Indonesia, as I following up the discussion, when we're talking about the data protection, it's always have some debate about the data sovereignty. And could you explain a little bit more about what is actually the data sovereignty concept is? Is it really close with the conventional or offline jurisdiction that we often know in offline? Is it same, the jurisdiction, since we all know that in the internet era, the sovereignty is like cross-border? What do you think about it?
So first of all, I would like to explain about the data sovereignty. Data sovereignty is a concept that digital information is subject to the laws of the country which it is located. So it is physical. So it must be inside the jurisdiction. But that in the digital age, that is difficult to achieve, since we live in the cloud era. So the data reside anywhere. So it could be in country, it could be in other country, it could be sensitive, it could be non-sensitive. So we must adapt to the newer situation. So I think the concept of the data sovereignty in the digital era should be changed. Even though by definition, the sovereignty related to the geographic area, but in practicality, the data can reside anywhere. And in Indonesia, there is a regulation in our constitution and also in our regulation that basically the government must protect the citizen data. And it is easier if the data is resides within the country. But the problem is there is no guarantee that the data is safer in the country. So maybe the data, the definition of the data sovereignty could be changed in the digital era. But of course, if the data is stored outside the country, it will be slightly more difficult for our law enforcer to get the data and more difficult for our government to protect it. So maybe to make everything simple, just state the data must reside in the country. And however, if the citizen is okay, it depends on himself or herself. He or she can decide whether her data or his data is put outside the country. And there is a mechanism. For example, the law enforcer needs some data. It actually doesn't really care whether the data is within the country or outside the country, because the technology allow the law enforcer to get the data, no matter the data is. Even though the data is located in different jurisdiction, there is a multilateral agreement, treaties, that allow us to get the data. So for example, we are Indonesian citizen or Indonesian government, and we want to get data about our citizen, but the data is stored in certain country. We using the multilateral agreement, we can get that data, but the problem with that is maybe it takes some time to get it. It can be months, can be 10 months, but if it is inside the country, it is easier. Just send the law enforcer into that location and then seize the data. So that's, I think, in terms of technology, it doesn't care, but in terms of other aspect outside the technology, I think it's still important that the data stored in the country. Maybe that's my opinion.
Yeah. Following up your explanation, my question is data localization, you mentioned about the data localization, is it really enhance the data protection regime? So what do you think about it?
So actually, if we are talking about the data protection, there are several factors. For example, the first one is where the data is resides. So this is called data residency. And the second one is the privacy, how the data is, the privacy of the data are protected. And the other one is, the last one is data security, how to ensure the data is secure. So not only the location, there are three aspects: the residency, which is the location, and second is the privacy, and third is the security. In terms of location, of course, within the country is easier to protect it. But outside the country, it's not impossible to access. The protection is there, but the protection is controlled by other means. For example, data security is controlled using password anonymization, two-factor authentication, digital rights management, and there are several standards: ISO 27001, 27017, and in terms of data privacy, there are other standards: ISO 27018, GDPR, and in terms of technology and control, there are masking, etc. So not only the location of the data is important, but there are three things that is important. The first is maybe the location, which is the residency of the data. It can be in Indonesia, it can be outside, but it is easier if it is in Indonesia because it is nearer. It is nearer, it's faster to get. It doesn't need permission from other country to access, something like that, because it is the data is inside our jurisdiction. But it is not enough. We need the data privacy, which is controlled by other means, and there are contract obligation, audit, and the third one is data security. So there are three components in order to ensure the data privacy and security is maintained and can be accessed by the law enforcer or by the owner itself.
Thank you, Pak Tony. Yeah, that I think like the other speakers mentioned about the data protections regulations also, and the several in their videos mentioned about the right to protect, especially once the law enforcer trying to meet some data, it should have a legal basis. And I guess the data protection help us to give the legal basis for the law enforcer get our data. Thank you for the explanation about the data sovereignty. So probably I'll go to Ingo. Is GDPR have in GDPR there is a similar discussion about the data localizations, and it's data localizations enhance the data protections. And my second question is probably you can add more comments about the data protection authority, like Ploy and Mas Wahyudi mentioned before, and how does the GDPR actually define the independency of data protection authority?
Yeah, thanks. Well, on the question of data localization, I agree with what Tony Seno Hartono said in the beginning, that data is obliged to be stored in one country doesn't mean that it's protected better yet. It can also be exploited in many ways, also by governments, for example. So GDPR, I mean, one of the objectives of GDPR was to harmonize European data protection laws so that there is some sort of digital single market with free flows of data inside the European Union. So it is not, so in general, as long as your data processor inside the European Union, it doesn't matter where, in which country in the European Union you're situated, but there's also ways for companies, for example, to transfer data outside of the European Union. But there's many debates about this, for example. So countries like the US did, or like just recently Japan did, they can come to an agreement with the European Commission that, or the European Commission can come to the conclusion that the data protection, the level of data protection inside another country is equivalent to the level of data protection inside the European Union. So it is easier to transfer data outside the European Union, but there has to be like a set of norms and standards and control in the other country. So Japan wanted easier access to the European data market. So this is why they kind of changed data protection laws in Japan. They kind of installed the independent oversight bodies. And then the European Commission said, okay, we can now say the data protection level, the level of data protection in Japan is somewhat equivalent to the one inside the European Union. So it's easier for Japanese companies to transfer data from the European Union to Japan. Yeah, maybe that's on so much on the question of localization. I think really the what Wahyudi said about I hope I pronounce the name right, about authorities is a crucial part, because you mentioned the California Consumer Privacy Act, and there's also in other US states there's debates about the need for privacy laws, but in most of those there is no oversight, or at least no independent oversight body. And if there's one thing we can learn from the history of data protection in the European Union, then it is that without proper enforcement by authorities, data protection authorities, when they don't have the means to control data controllers, to actually look at them, to also sanction them, then it is like there is no data protection law. Or maybe it's not that bad, but still enforcement is very, very important. And this is why kind of the GDPR changed the game here by, for example, saying that in every European country, the data protection authority, it has to be independent. So in Germany, it really is or in Germany, for every federal state, there's one authority, and then there's one for the whole country. And independent really means that they have to be equipped by states, but there's no actual Parliament votes on who's the data protection supervisor, but apart from that, they're kind of fully independent. I mean, at least in how they act. I mean, there's still those oversight bodies. They also have the oversight over what governments do. So there is kind of a conflict of interest somehow. Especially since it's the parliaments and governments who decide how much money, how many resources the oversight bodies they get. But still, if you compare it, for example, to the situation in the US, and as I understood in some countries, Southeastern Asian countries, at least there is some form of independent oversight, and it's equipped in a manner that is at least on a basic level sufficient to do the oversight work, and they have the powers to sanction violators of GDPR. And I guess this really is the main game changer, one of the main game changers with GDPR, that for companies, for example, it's not only compliance issue now, but it's a financial issue for them. So also, that's what I heard from internal data protection officers at companies. They said, now I have my seat at the table. I can if there's a data protection issue inside the company that the internal supervisors they find, they now have a means to go to the board, for example, and point out, it's not only because we should do it right, but it's also because there's a huge financial risk if we don't do it right here. So yeah, I'd say this is, besides the question of rights and the concepts of rules that come with GDPR, the oversight and the risk that it brings for violators is crucial part.
Thank you, Ingo, for addressing the oversight mechanism that should be addressed in data protections implementation. So I'll go back to the ploy. So for ploy, do we really in Southeast Asia, do you think we need like some sort of mechanism in the region context, like a GDPR, in order to improve the data protection in Southeast Asia country, or for example, ASEAN country? As you know that most of Southeast Asia countries are big countries with a very big population, which means we are a very big market in order to company collect our data and behaviors. Do you think we really need the robust mechanism in ASEAN countries, or is privacy framework that ASEAN have right now is enough to protect our rights?
Well, yes, we do need the robust personal data regulation with GDPR as an example. It's because what we have right now is not robust enough. Well, we don't have the when we don't have the regional data regulation, there's a lot of challenges in terms of how data is dealt in terms of at the regional level. Like, for example, last year in 2019, we know that there was 2 cases of data breach that occur in terms of the regional level. So one case was the cosmetic company Sephora, and the other case was the case of Lion Air. So in terms of Sephora, what happened was that as I remember, there were 8 countries in Asia and Pacific that involved in terms of data breach. So 5 countries in Southeast Asia, Malaysia, Thailand, Indonesia, Philippines, and Indonesia. And the other 3 is Australia, New Zealand, and Hong Kong. So the data breach happened at the same time, but the way that the company dealt with the situation is different in this country. So as I look, Australia, New Zealand, Hong Kong, and Singapore, they will offer some kind of personal data tool. I can't remember the exact name that the company offer, but it's the tool that, you know, when you actually enter your email address, so it tell you where your email go, whether it's already in the dark market or not. But in terms of country in Southeast Asia, the customer was told that, okay, please change your password, just that. So you see that there's a kind of discrimination here in this case. And also the recent case that happened is with Twitter. Like, I think it happened in mid-April. So when so Twitter just announced that they remove actually the feature that allow the user to share, to control how their data is shared with the business partner of Twitter. So those who are protected under the GDPR, this option, well, this feature is still an option. They can still remain private in terms of their personal data, but the rest of the world, those who don't have the robust data regulation, this is not an option. They are not allowed to control whether they want their personal data to share with Twitter business partner or not. So this is why the robust personal data law is really important in this case. And also, when the existing personal data that happen in the region, I mean, in countries that have the personal data at the moment, I don't think that they don't really address the way big tech operate in the country in terms of harvesting data, in terms of how they deal with the data of the citizen in that country in particular. And also, I think that there are cases that happened before when the regulation is so weak that non-state actor, like, well, if you read about the case of the Cambridge Analytica, so the Cambridge Analytica case is not just it didn't happen only with the election in 2016 in the US, but there was detail that it also happened and actually has an influence over the 2016 election in the Philippines as well. And actually, I got this from the article that it's because the weak data regulation, that means it allowed the opportunity for this kind of company to use Southeast Asia, country in Southeast Asia or elsewhere that have weak regulation as a playground to test their strategy, because it's easier for them to get away with it because the regulation is not that strong. So this is why the strong and robust data regulation is really important, and it needed to be implemented at the regional level. But I don't see the opportunity, the opportunity that for it to happen at the moment because of the political issues. So, in terms of having the data, the robust data regulation, you need to involve all the stakeholders as part of it. And when the majority of the country still exclude the government sector to be part of it, it leaves a really huge gap for the regulation to be called robust or strong. Yeah, and when the majority of the country are actually considered as authoritarian or repressive regime, governed by, ruled by a strongman, something like that, it's really hard to make something as like a legal abiding regulation in this case. And I think that if ASEAN want to take an action on this, it would be like a huge challenge for them. But it's something that I really think that they need to act on it. Yeah, despite the political challenging situation.
Thank you, Ploy, for very comprehensive explanations and the challenge in Asian. So maybe we can like move to participants' questions in Slido. So I'll read some questions here. First, probably I'll take the questions about the data sovereignty. So it's from Alci. So it's for Pak Tony. So Alci said that on Slido. Sorry. Wait. While theoretically MLA can work, how international politics and business will influence the work of mutual legal assistance in reality? Patani, please, could you answer that question?
Yes, MLA work in a multinational company. For example, we store data in other countries, and then the government needs to access the data without informing the user, for example, and the government or the law enforcer will work through the MLA, the multilateral agreement treaties. But the issue, of course, working or relying on MLA is very time consuming, and this is the only way we work today. So for Indonesia, for example, Indonesian company store data in some US cloud service provider, and then Indonesian government needs the data, and Indonesian government must actually the government must ask the user about the data. That's the first step. And if the government doesn't want to ask the user, then the government will ask the provider. But the problem with the provider is that it depends on what kind of services. If it is SaaS, software as a service, maybe the provider knows the data and can get the data, but it needs some the government to fill in the form, and then it can take months before the answer of that request. First, the provider will check if the request is valid. If it is backed up by the court order, something like that. If it is valid, then the data can be given. There are two types of data can be given. The data that is created by the user, this is more difficult to get. And the easier one is the log data. The log data is easier to get. And right now, there is no other mechanism. So that's why the Indonesian government asked the data in terms of personal data, in terms of high priority data, sensitive data must be located in Indonesian border. So the government will not go through the MLA process. So the government will ask the local company to provide the data without MLA. So that's the practice today. And if we put the data in international cloud provider, global cloud provider, it depends on what kind of company is that. Because some company may be easier to get the data compared to other company. So there are several global company. Other company maybe make the put more security on the customer data. So it will be very difficult for the government to get data for that certain company, but other type of company it's easier. And you can look at the agreement, and there is usually one portal in that service provider that describe how the government can get the data. Hopefully that answered the question.
Thank you, Pak Tony. So I wanna Mas Wahyudi to add some more, especially about the current situations about the data protection regulation in Indonesia, and also there's the questions in from Sayo to Indonesian panelists in the current bill of data protection regulations. How big is the power of government over citizens' data?
Thank you, Lintang. Yeah, in the current situation of the legislation of the regulation of the data protection in Indonesia, the right to privacy as a part of the constitutional rights. It is mentioned in the Article 28G, paragraph 1, about the private life as a part of a private life, and the article refers to the Article 12 of the Universal Declaration of the Human Rights. And in the level of laws, based on the ELSAM studies, we found more than 30 laws in Indonesia with the content of the data protection in the several sectors. For example, in the sectors of the information and telecommunication, and the sectors of the health services, and the third, the sectors of the administrative population and the archiving, and the next, the sector of the trade and the industries, and also the sectors of the banking, financial services, and taxation, and the last, the sectors of the national security and the law enforcement. But all of the laws in Indonesia with the content of data protection have yet of the follow of the data protection principles. So we have the several problems in the content of the law. For example, in the law of the information and electronic transaction, the law number 11 on 2008, the article about the data protection, personal data protection, just found in the one article, in the article 26. It is about the forbidden to transfer or exploitation of the data without the consent, or forbidden to the processing of the data without the consent of the data subject, just it. But there is no mechanism about the rights of the subject data, the obligation of the data controller, and the obligation of the data processor, even the mechanism of the dispute settlement will the data breach or the abuse of the data. But currently, the government have the new regulation, the government regulation number 71 on 2019 about the electronic system providers, or implementation of the laws of the information and electronics. But the government regulation just mentioned about the obligation of the electronic systems providers. So it is talk about the obligation of the data controller and the obligation of the data processor, but not accommodate about the rights of the subject data. And the other laws, for example, in the health services, the health law, the medical law, and the other sector, also just the little regulation or little the article about the data protection, the mechanism. So currently, we need the comprehensive the data protection law to explain to explanation about the definition of the personal data, the categories of the data, to explain about the rights of the subject data, the obligation of the data controller and data processor, and it is accommodated in the bills of the data protection, but without the independent supervisory authority. So we hope the bills will deliberate in the House for the next month, and we can discuss about all of the principles of the data protection, including the issue about the principles of the data protection, data processing, and how to set up of the independent supervisory authority to oversight the implementation of the data protection law, and how much the government's control of the data from the citizen or from the public. Currently, all of the ministries in Indonesia have the program One Data System. So all of the ministry or state agencies try compiling all of the data from the public. For example, the Ministry of the Ministry of Home Affairs, they have the responsibility to manage of the administrative population data or citizenship data or identity data. And based on the identity data, the Ministry of Home Affairs have the cooperation with more 100 of the private institution to access of the identity data or identity system database. And based on the cooperation, based on the memorandum of understanding, the Ministry of Home Affairs also get the data feedback from the private sector. So the government can conduct of the profiling all of the citizen based on the data feedback from the private institution. So currently the government have the Big Data Indonesia. They call Big Data Indonesia. It is data about all of the people in Indonesia based on the ID system database and based on the data feedback from the financial services, telecommunication company, internet services, etc. So I think the situation in Indonesia.
Thank you, Mas Wahyudi, for very comprehensive and also the challenge that Indonesian face in order to pass the bill. So my next questions from Slido is for Ingo. So there are plenty questions here. Like first, probably I'll take about the open data. So as open data increasingly to be applied, there is a fear that it opened the whole of personal data protection rights, especially since anonymization not solid. What do you think about this open data and the whole of the personal data protection?
Yeah, I agree. We can make it this short. I agree. No, I think really that is. I mean, there's a tension between the need for open data and the need for privacy protection or data protection somehow, especially since we see that that anonymization is a concept or is an idea that in practice, or that is great in theory, but in practice is really hard to achieve. So this is actually an ongoing debate in the EU as well, as to at which point data that was former personal data can be can be used or can be seen as anonymized, because this old idea that it's just enough to have a database and then you cut out the names or identifiers like phone numbers and then it's easy to publish it or to use it as anonymized data. This doesn't work, because researchers have shown over and over again that if you take other data sources and combine them, it's often possible to re-identify people. But still, I want to point out, I mean, really, this is an ongoing debate in the EU as well. And there is kind of common agreement that there's a need for some sort of standardization for processes of anonymization if we really want to make progress here. But I want to point out that there still is a lot of data that can be used as open data, especially if we talk about government open data, that is not that doesn't entail personal information and that does not conflict. So, for example, data about tax and business, like businesses, like data about the where the state spends the money, contracts that the government has with companies, for example, environmental data, like mobility data, also can be used in a statistical or aggregated level. So there is still lot data, especially government data, that can be used as open data, where we don't have to worry about personal data or the question of re-identification. But still, a very good question. Yeah, that still has to be solved.
I guess it's also the challenge in Indonesia, for example. There's a debate about the open data and also the data protections. And I guess we can move to the next question. So this from Chatur. My research about digital literacy index of youth in 5 cities show low awareness about digital data security. And how can we increase this awareness? So I guess it's for all speakers, and probably I'll start with Chloe.
How to increase data digital security, right?
Yep, it's true.
Okay, so I think in terms of well, from what I know, the digital literacy in many countries in this region, people are, well, it's still very low, and people tend to believe what they see on the internet, especially Facebook. And I think that in this case, it's also, well, it needs many stakeholders to involve. The government needs to encourage this kind of skill, this kind of like, for example, introduce like a digital security program, digital literacy program to the citizen. And also they need to encourage some kind of like press freedom information as well, so that they receive the accurate information regarding to what happened, things like that. I think that this kind of skill is really important, given the political, I mean the situation where fake news is so spreading in the wide scope here in the region. And digital security is really important, and also it's about like how people can keep their privacy private. For example, the way that they use technology in their daily life, for example, starting from what browser are you using, which kind of browser that is pro-privacy or not pro-privacy, what are the business model of the company that operate behind it, whether they make the revenue from advertisement or not, what kind of messaging application are you using to talk to your friend, what is the best messaging application that you should use talking to your colleague, because there might be some sensitive issues that if it's leaked or if it's will or known by a third party, it will be a burden for both parties, things like that. Or something that, the way that you live your life with the technology from in every day. Yeah, the browser, the email, things like that. This need the stakeholder, the government, NGO, any stakeholder to introduce the program and encourage people to gain more knowledge and more skill in terms of this kind of digital literacy and digital security.
Thank you, Ploy. So, Pak Tony, could you give a comment about the digital security awareness? What we should improve?
Yeah, in Indonesia, a lot of stakeholders already have the same concern about the awareness of digital literacy. And in Indonesia, there is a movement. It's called Cyberkreasi. It's called ICT literacy movement. The objective is to increase the literacy of IT in every stakeholder in Indonesia. For example, from the company to the household. So we created a lot of content related to security, to privacy, to technology, and the audience could be student or housewife or every Indonesian citizen basically. And usually we do this activity by visiting the community, but now since COVID era, we do it through the digital technology. So I'm also one of the member of that society movement. So I think that's one of thing that we can do in Indonesia. And other than that, there is a lot of program from the company, from the digital company, citizenship program, or like a free education about security, about privacy. We can leverage that program too. So this movement is having some collaboration with several organizations, international organizations. Everything that they do to increase the literacy, let's move together. Let's collect the program together and move together. Hopefully, we can increase the digital literacy index in Indonesia. Thanks.
Thank you, Pak Tony. So, Mas Wahyudi, could you add some more about it, especially how we define the digital literacy? So, because as we know in Indonesia, the digital literacy is more about how to use the technology, but how do we improve the privacy and security in our digital literacy? And should we address it in the bill, data protection bill?
The issue about the digital literacy in general, or digital security literacy in specific, mention about the information from Pak Tony. I think in Indonesia we need of the systematic approach of the digital literacy, because currently the movement, the initiative based from the several civil society organization or from the Ministry of ICT or the other stakeholders. But in this situation, especially in Indonesia, with more than more than 100 billion of the internet population. So we need of the work together and in the systematic approach to conduct of the digital literacy. And the one phase of the digital literacy, the about the digital literacy, we talk about the scope or the element of the digital literacy, because it is not enough if the digital literacy just said about the how to use of the your smartphone or how to use your PC, your laptop, etc. So we try to identify or to give the definition about the digital literacy itself. We can reverse to the several of the definition about the digital literacy. For example, from the American Library Association, it is about the holistic approach of the digital literacy. Or in 2019, the UNESCO also released about the models of the literation of information on information literacy, because information literacy is more than high of the digital literacy. It is about the capacity of the reflective capacity of the peoples to considering their information and to spreading of the information. So they just not of the handle their cell or their smartphone, but how to consider the information accept by the peoples and send of the information to the another people.
Mas Wahyudi. So Ingo, do you have any comments? As we know in GDPR, there's a principle or one of the obligation for data controller to make privacy by design and privacy by default. Is it really have a big impact to make awareness to European citizens?
I'd say yes. Like education, digital literacy, and especially security and data protection literacy does play an important role, and it's very, very important to educate here. But yeah, exactly. I want to stress that, in my opinion, there's a limit to what we can achieve by educating people on data literacy or on data privacy, because data flows and modern technology, ICT technology is so complex, and it's connected and networked, so that it is impossible for any individual to understand all the ways the data flows. For example, if they use a social media. Maybe you also have seen the Senate hearing with Mark Zuckerberg, CEO of Facebook, 2 years ago. He wasn't able to fully explain and to point out how the data processing, or how the processing of personal data inside Facebook works. So how the tracking of users offsite Facebook on third-party websites works actually. So if CEO of this company isn't able to fully understand and explain the way the data is used, the way the data is collected, the way the data is exploited and monetized here, how are we as individuals, could we be in the position to understand that fully? So I just want to say that education, as important as it is here, it is no replacement for proper legislation and enforcement of data protection. And to some extent, this is reflected inside the GDPR, as you pointed out, Lintang, for example, by the obligation for data processors to do data protection by design and by default. So, I mean, data protection by design is still a very much ongoing debate, how to understand this, but I'd say data protection by default is a very important aspect. So me as an individual individual, I don't have, if I can rely on one fact, is that if I install an app, if I start using one technology, I don't have to look up the data protection menu first, but I can rely on the fact that it is set to the best protected level. Although also here we can see that the one thing is what the law says, and the practice, the day-to-day life, is a different thing, and we see many problems here concerning the enforcement of the obligation for data protection by design and by default. There still is a huge lack, but in theory, I think this is the way. Yeah.
Thank you, Ingo. So I guess your final statement is very relevant with the questions that I found in Slido. So there is a questions about how, this is the popular one, how can you know if a public or private institutions are really complying to the privacy regulations? I guess it's also relevant when we're talking about how the DPA works, and maybe you can share as a citizen, EU citizen, how exactly the process to ask the DPO, or if you consider there's a violation of your privacy. Maybe Ingo can explain.
Yeah. Also, a very, very good question, pointing to one of the problems with GDPR. And it really is, me as an individual, I cannot look inside the data processing. I cannot look inside the company or the authority or the ministry, for example. So one way is to ask the company to hand out the data that they have about you. So me as an individual, I have the right to do that. I can ask the company, for example, the data controller, to tell me what they know, and then I at least could get an idea, and I could get a glimpse of what they do with the data, which data they have, and if I get suspicious, then I can talk to the authority. I can file a complaint with the authority. But this can never fully work. So it is important that the authorities have the capability and the resources and the competences to also do like controls on their own. So so they have and they do this they from time to time, at least for Germany, they look at special sectors and they say, okay, we will have a look at here now, and we ask companies to show us. But yeah, also since data controller, also the DPAs, they cannot be everywhere, especially since although they have the resources for them, the equipment has grown and is better now, they still lack, for example, a lot of technical competences to understand how the data processes work in many companies or contexts. So we still rely on people inside companies, for example, or inside ministries, if there's issues, if there's violations of GDPR, to come up, make that public, speak to the public. If you think of Cambridge Analytica, the scandal blew up because there were whistleblowers making public what was happening. So I guess this is an important element that obviously cannot be in the law, but I still think as a societal idea, I think it's important to embrace this idea of people speaking to the public if there's ongoing violations. Yeah.
I also think that even though the implementation is not really perfect as the theory, I guess we are as a user have to still exercise our rights and ask the obligation from the data controller, since we have the law basis. So maybe I wonder how the citizen situation in Southeast Asia ploys. Like you mentioned about the data breach, like in what happened in Southeast Asia, like Sephora and Lion Air, and how does that happen? And is there any like in some Asian countries who have who already have the data protection? Is there any like a ongoing process in terms of the violation?
From what I know, there are cases in Singapore, for example, that well, since the CDPR came into force, it looks like it alert many countries in Southeast Asia in terms of strengthening the data regulation enforcement as well. And I think that Singapore seems to be making most progress in terms of this. And from what I know, there are cases already in terms of company that experience with data breach, something like that, and it got fined from the Singapore authority. That's what I know. In terms of Thailand, not yet, because even though the law has been passed, it doesn't come into effect, hasn't come into effect yet. In terms of the Philippines, from what I know, there was a situation in terms of the data breach in 2016 with the Election Commission, the COMELEC, and I think that from what I remember, the person, I mean the team or the person who's in charge with the data, they also got their face with the lawsuit as well. Yes, and that's what I know. They either got fined, facing lawsuits, something like that.
Can I add one point that I kind of forgot? What we saw in the EU is that also NGOs can play a big role in kind of shedding light to violations that happen. So we saw that there were coordinated campaigns from digital rights NGOs who kind of said, for example, who asked the public together to do some access requests for data, then hand in the data they got, and then they kind of analyzed it at the NGO, and then they were kind of had the way to to comprehend what was happening, and then and also we saw some coordinated campaigns by European NGOs that were kind of bringing notifications to the data protection authorities. So they not only can ask or can gather knowledge about what is happening, but they can also be the ones who are kind of the advocates and bring the interests of citizens to the data protection authorities and also to the courts. So I think there's a crucial role that digital civil society can play in this as well.
Thank you for pointing out the importance of multi-stakeholder approach on this data protections issues. And I guess we can move to the another questions, and it's for Pak Tony and Mas Wahyudi. The question from Muhammad said that infrastructure-wise, electricity, SLAs or ATC, do you think Indonesia is ready for data localization? So probably Pak Tony can answer first.
Yeah, this is very interesting question regarding the infrastructure in Indonesia. In some city or some location, it's not the same with the infrastructure in other locations. So I think the problem is not the infrastructure in Indonesia, but the availability of a proper infrastructure in certain location. So if we are talking about Jakarta and its surrounding, I think we have the infrastructure that support the data localization, but the problem is if what if the infrastructure from other city, for example, in Papua, for example, the electricity is maybe not as stable as in Jakarta. But even though in Jakarta there is infrastructure, we need a very robust architecture. For example, the cloud provider, basics cloud provider, the global one, they can commit 99.95% availability of the infrastructure. And if we want to implement that in Indonesia in the most stable area, maybe we need 4 electrical source. Maybe we need 2 or 3 different service provider just to turn on this one data center. And but using the current technology, for example, the cloud technology, we can use cloud technology and implement it in Indonesia. Maybe we need 5 to 10 data center in Indonesia and then interconnected them together to achieve that availability 99% or maybe more. So infrastructure is there. We can address the weakness of the infrastructure using the proper technology, but the problem is maybe the cost is very high in Indonesia. So usually the cloud service provider have a very cheap electricity and their source also renewable. And those things are not available in Indonesia. For example, we need a solar panel or the ocean wave or other way that is not available in Indonesia. Mostly we use diesel, we use fossil power, so electricity is not that reliable. It can be addressed by a good architecture, but the cost is very expensive in Indonesia, and also to achieve the same reliability that the global cloud service provider has. But that is not impossible. That is possible. It's just very costly.
Thank you, Pak Tony. Mas Wahyudi, maybe you can add more, especially our legal perspective.
Yeah, thank you. First, I think I have the different view about the data localization with Pak Tony, because I try to give the border about the data security and the data protection and how to defining of the data sovereignty in the digital era. Pak Tony mentioned about the changing of the digital sovereignty concept currently. It is not about the territory, it is not about the geographical landscape, or it is not about the jurisdiction, but how the peoples in our perspective. The digital sovereignty mention or definition, it is about how the peoples can control their data, how the subject data can control their data in any place, in the data storage, the place of the data storage. So why we try to creating the comprehensive and the strong data protection law, because the subject data have the authority to control their data. It is different with the issue of the data security and the issue of the jurisdiction, because it is about the currently most the people defining the data sovereignty as data localization, but so many the type of the data localization in many countries. For example, in Indonesia refers to the government regulation number 71 on 2019. The Indonesians follow the models of the specific sectors. So just the strategic data have the obligation to storage localization in the territory of in the Indonesian territory. So I think the strategic data it is have the relation with the government data, and the others data with a specific sector. And currently, the government also try to set up of the resource to building or to develop of the local storage in Indonesia for the strategic data. But the issue of the access of the law enforcement agencies or the intelligence agencies to the storage of the data, it is also the important discussion in Indonesia, because currently we don't have the strict of the procedure how to the law enforcement and the national security agencies or intelligence agencies can access of the personal data. For examples, in the European Union, they have the EU directive on the data protection in criminal conviction, EU directive 680 after the EU the GDPR. So they have the limitation how to law enforcement agencies can access of the personal data based on the case and with the strong oversight from the court. In Indonesia, all of the law related to the law enforcement agencies or procedural law, it is have the different procedure how to access of the personal data from the data storage. So I think it is the challenging in Indonesia because the providers or the digital platform also have the problem. What is the strong law or the specific law regulate about the procedure for the law enforcement agencies to get of the personal data as evidence in the criminal cases, for example?
Yeah, thank you, Mas Wahyudi and Pak Tony. It's a very interesting discussions because in Indonesia, when we're talking about the privacy and data protection, is always have a discussion about the data localization and also, yeah, as a data sovereignty concept. So I guess we can move to another questions here. We have a pretty much about asking the participant wondering about the GDPR. So probably Ingo can answer this. So there's a question: in what ways do the GDPR influence, or probably not influence, the business model of certain digital companies such as Facebook, Google, or etc., which relies heavily on extracting data? And the second question is also about the sorry, I think I lost it. Data mining. So do you think GDPR has success combating data mining, which makes a big multinational company who often escape from the law? So thank you. So please, Ingo.
Yeah. Again, very good questions, because I mean, GDPR is applied since 2 years or closely, nearly 2 years now, and so far we haven't seen that it changed the business model of GAFAM companies, especially Facebook and Google. We didn't see that it changed their business models and the way they extract data. In fact, many people argue that for those multinational companies with huge legal departments, it was fairly easier to be compliant, because they have the legal people to do that. So their approach was not to change how they process the data, but their approach was to find legal ways to comply and to make the way they exploit data yeah, kind of compliant with GDPR. But there's many cases with the data protection authorities which are pending, where citizens and NGOs kind of complained about practices that are happening with Google and Facebook, but those cases are still open. So this points to one of the issues with the enforcement of GDPR that is still to be solved, is that although individuals can file complaints in every member state, nevertheless, where they live or where they are at the moment, still the leading data protection authority is the one in which the company, which is a complaint about, is having the department, for example. So this means that for Google and Facebook, the Irish Data Protection Authority is the leading authority, which is known to have a more business-friendly approach to data protection than, for example, the French or the German data protection authorities. And right now, there's huge debate among those national authorities how to come to a common conclusion, because the Irish can't decide alone, but still they're in the lead here. So this is going to be very interesting. But from what we can see right now, we have to admit that, or I have to admit that the business models and the data practice at the way data is exploited and used with Apple and or with Google and Facebook, it didn't change much yet. Yeah, same for data mining and the issue of big data. Yeah.
Okay, thank you, Ingo. So, Ploy, maybe you can add some in how the impact of GDPR to you mentioned earlier about the impact, some impacts on the business in Southeast Asia countries. Is there any a big change in terms of the data protections implementation?
From what I know, not really in terms of well, not in Thailand, of course. In Singapore, I think because the government is trying to straighten the law, so it kind of make the business sector to pay more attention to how the company deal with the data, but still we still see the incident of data breach regularly in the country. In terms of social media company, big tech, I don't think that there are a big change in that. No.
Okay, sadly, it's a sad condition.
Yeah.
So maybe we can go to another question. So I guess it's related with the current condition about the COVID-19. Like, as we know, most of the government around the world trying to using technology in order to fight COVID-19, and in some way the technology seems to sacrifice the privacy. So for all the speakers, probably I'll start with Mas Wahyudi, because there's a specific question to Indonesian panelists. What we will know the next, how about the regulation privacy citizen during this COVID-19?
Yeah, I think we have the several issue of the privacy in during the pandemic of COVID-19 in Indonesia. The first about the issue of the health data from the patient of the COVID-19, and the second is about the use of the apps by the government to tracking, tracing, and fetching of the COVID-19, and the third the issue about the telecommunication data during the COVID-19. For the issue of the health data of the patient of the COVID-19, we can follow the several laws in the health sectors. For example, the health law and also the medical doctor law and the law of the hospital. The law talk about how the obligation from the health services and also the doctor to keep or to what is the protect the secrecy of the health data, including the identity of the patient. And we have the debate in the public in Indonesia because the several community, several association try to praise the government to opens of the identity of the patient of the COVID-19, but the government have the position to keep of the data or identity of the patient of the COVID-19. And the use of the application Peduli Lindungi in Indonesia, we found several problem with the application because there is no what is strong privacy policy and enough of the term of services about the application, and also the application still try to collect of the several data, the irrelevant data with the COVID-19. For example, the data from the memory card of the smartphone and the data from the photos and the videos from the smartphone, and it is irrelevant with the COVID-19. And also, where is the storage of the data from the apps? It is storage in the phones or in the smartphone, or storage by the centralized storage provided by the government. And there is no what is the regularly audit or refer to the data protection principles with the principle of the transparency and accountability. There is no data protection impact assessment in the use of the application of the Peduli Lindungi. So it is the several problem with the data protection principles, especially in the issue of the purposive limitation principles, the data minimization principles, and also storage limitation principles about the data protection. And the others about the data expired or the retention of the data, it is also still debatable. It is just for the period of the rapid response, or the government will storage of the data in long life situation or etc. And the others, I think it is about the presentation of the people's install of the application, because until now it is just the little community, the little the area in Indonesia install the application to use of the Peduli Lindungi, and it is also the problem of the digital divide in Indonesia, because the infrastructure just good in what is strong in Java's area, but the COVID-19 currently the transmission process widespread in all of the territory in Indonesia. And about the data telecommunication, it is also part of the use of the apps. So I think it is also the question about the who can the access of the data related with the COVID-19. It is just accessed by the Ministry of Health. It is just accessed by the Ministry of Information and Communication, or also the telecommunication providers can access of the data about the COVID-19. So it is also the debate. So based on the situation, we hope the government have the initiative to reverse of the several instruments, the policies from the government, especially in the government regulation number 21 2019, and also the Ministry of ICT regulation on data protection in electronic system. How the Ministry of ICT can provide the regular audit in the use of the application of the Peduli Lindungi.
Thank you, Mas Wahyudi. Pak Tony, would you add some more, especially in Indonesia context, from industry perspective? Like, is there any like a certain protocols when the industry processing the what specific or sensitive data, especially during this COVID-19?
Yeah, during the COVID-19 problem right now, it looks like that every industry try to collaborate together. It's not only the industry, but also the government sectors, the society, the university. Every organization in Indonesia tries to work together. But the problem is there is no standard of interoperability in Indonesia. So we can see, if you are in Indonesia, you can see that almost every organization, every company, every people that can that understand to create application, each of them create their own application, use their own data, and one data could be different with the other source of data, and all the data cannot be integrated. So this is the problem that we are facing today in terms of technology. If we see from the technology provider, a lot of company they have program to fight the COVID-19. They issue they allow people to use the application for free as long as it is used for work at home or something like that. But other than the company and organization, I see also some regulators also aware that they need to issue some regulation that that can be used during in the COVID-19 era. For example, in the healthcare industry, there is a lot of discussion inside the Ministry of Health, Indonesia Hospital Association, and how we can share data, etc. And just several days ago, on April 30, the Indonesia Medical Council issued a regulation, and this is the regulation about the telemedicine. As you know, during this COVID-19, doctors also afraid to go to the hospital to meet the patient because there is a higher risk for them to get infected by the COVID-19. So the platform like telemedicine is used everywhere, and we need some regulation. And it's very good that the Indonesia Medical Council issued the new regulation several days ago. And in this regulation, actually there is some stress of the doctor and dentist must be registered if they must be registered in a hospital, and then the teleconsultation is allowed, but must be with the hospital involvement, and the teleconsultation must be recorded in a medical record. So previously there is ambiguity in using the telemedicine. A lot of organizations issue telemedicine application, but without the proper regulation. So the doctors in Indonesia are limited to practice in 3 locations using the telemedicine. They can practice in maybe 5 or 9 or 7 or maybe 9 locations. Yeah, that's violating the regulation, but the regulation is not there, it's not clear. So there are several occasions this was happening. So what I see from the COVID-19 is the government try to leverage the technology as much as possible, but they also know that they have to issue some regulation that makes this technology adoption better and more effective. So this is what I'm seeing in Indonesia, in this industry, especially in the healthcare industry. In terms of other industry, technology industry, they try to offer a lot of solution and infrastructure that can help the people to work more effectively, or maybe to provide a better solution in the hospital or something like that. So this COVID-19, what I see is a good momentum for us to work together and to issue an effective regulations, yeah, to allow the technology to help us work more effectively, but safe and in a good privacy protection.
Thank you, Pak Tony, because we have very limited time. So, Ploy, do you have something to add? Because I saw the articles from Digital Reach write about the threads together.
So we cannot really examine the code of the app actually, because it's obfuscated, and even though the code, they said that the code is available on GitHub, is actually not the actual code of the app, but it's how do I say it? It's actually the example of how the code can be used to build the app, things like that. So I'm just not really sure whether, I mean, when we cannot examine the app, so it's not transparent in terms of what the app actually does, even though, okay, let's put it this way. The government claimed that the Blue Trace protocol and the app is really, really respect the privacy of the user. But then when we cannot examine it, the actual code of the app, so we just, the belief, we have to trust what the government said without having the opportunity to actually testing whether it's really according to what the government claims or not. And I don't know that after the Trace Together has been used, whether there are other country in Southeast Asia or elsewhere that also build their app based on this protocol or not, because there's some point about the Blue Trace protocol that it actually decentralize the data and put it in the database. And this is actually make it more risky, because compared to other protocol that other tracing app might be built on that are using the decentralized approach. So when it's the centralized approach, that means if it's state run particularly, so the data, it would be held in the government database, and it makes it more vulnerable for the data to be misused, for example, make it into like a surveillance tool, things like that as well. And it also risky as well to those who run the backend server. So that's the thing that we don't know for sure. Yeah.
Thank you, Ploy. And Ingo, do you have any in European country? Is there any big discussions as well about the privacy and COVID-19?
Oh yes, there's huge debate. In Germany, we're debating, or there's 3 apps, for example, related to COVID that are debated. There's one in the debate about one app that should help control people stay in quarantine. Then there's another one where people can donate data they collected with their fitness trackers device to the health authorities so that they can do research. And then the biggest debate is obviously about like the contact tracing, the proximity tracing. And it's a debate all about Europe. Some European countries already have, like Austria or Norway, they already have some technical solutions, some apps for contact tracing. But in Germany and most of European Union, this debate is still ongoing. And the main question is the one that Wahyudi Djafar talked about, where should the data be located? Should it be processed on the decentral, on the phones, or should there be central service collecting data? There obviously it is easier, data can be easier used to do epidemiologic research if they are stored at a central server. But still there's huge mistrust in from people and civil society organizations to have this huge database on a central server that is run by the government or by an institute of like a health institute of the government. So after long debate, the German government, they kind of switched what they opted for. They were opting for the centralized version for a long time, but a couple of days ago, they decided that Germany would go for the decentralized approach or one decentralized approach. But still the debate is going on. For example, we debate about data protection impact assessments. Do they have to, I mean, you want to start an app like this in the EU, you have to do proper data protection impact assessment. But we have a debate about whether you as a data controller or government organization who brings this app should publish this data protection impact assessment. So to make visible, not only to publish the source code, but also the data protection impact assessment to show people how the data is used, kind of to enforce trust in what you do. And the other question we're debating is which legal basis can be used for this. It seems like government is going for like individuals' consent. So me as an individual, I can decide whether I have to consent, whether I have to use it or not. But people from the data protection community, they point out that there should be a specific law that is the legal basis for this, because only this specific law can lay down which data processes are granted, which are used for, and where they are limited, and also a specific law for this should lay down that it is or that it stays voluntarily to use this app, that you cannot be forced to use the tracing app, and that there's also no implicit pressure, for example, by asking people to show the app if they want to enter their office, for example, or so this is the debates we're going here, and I think it's going to be still some weeks until the tracing app is going to be published. I think it's going to be end of May. Some people blame data protection for this because it would be slowing down the process, but from what I heard, it's many different things. And data protection, the federal data protection supervisor is working together with the authorities to develop this app. And from what I heard, it's not actually, there's many issues with this app, but the data protection compliance is not the biggest issue here.
Okay, thank you, Ingo. So I guess we're on the closing time. I'm sorry that we can't answer all the questions, but this is very interesting discussions, and I can summarize all the discussions because we have a lot of great topics today. But the point that I have to address is we agree that privacy as a human rights and the regulations more or less, and even though we have our challenges, is still a big a big impact to build a better privacy environment. And also the most important things, especially probably for Indonesian government, who still in the process discussing data protection bill, we have to make sure that the regulations that we have is can enforce or can be implemented, not only the law. So I guess that's all. I hope this afternoon discussion will be fruitful and help everyone to understand more about the privacy, because I guess this is very interesting topic during this pandemic. And I also hope this is a interesting discussion during the quarantine. And again, I hope we're all safe and healthy, and hopefully we can meet in another discussions after this pandemic. So thank you, everyone. Good afternoon.
Thank you. Bye.
Thank you. Stay healthy.
Stay healthy too.